Okay, welcome to everybody, and thank you so much for being here today. So this is a start of a 2 days workshop on a book that will be forthcoming next year in the second half of 2022, a research agenda on gig economy and society. And the idea behind the book is to collect a number of contributions from different experts and people with different backgrounds that set the way for research around the platform economy for the future. So every one of the chapters of this book is going to be zooming on some aspects that are relevant for platform work and how platform work relates to other phenomena in the labor market. And also it is going to specify what are going to be the next things coming in platform work, what we'll be discussing in the next few years. I think there are some issues that we already, scholarship has covered extensively, some other issues that are really new, and that will probably get more space in the future. So the objective of the book is to discuss around these common themes in platform work and to see where we are going there and what could be a sort of research agenda for the future in the various issues that we are will be examining. I think we can start with a roundtable of the people who are already here. Alan, would you like to introduce yourself?
Yeah, thanks very much. My name's Alan Bogg. I'm a lawyer based at the University of Bristol. So I'm interested in the gig economy through a kind of legal lens, work particularly on employment status issues recently. But interested more broadly in the impact of gig economy on the way that we theorise labour law. So one of the things that's kind of struck me lately is that one can think about the gig economy instrumentally, and that's usually, you know, who is a worker and are these workers. But I think actually a more interesting, for me at least, kind of disruption brought about by the gig economy is thinking about what it means for how we think about labour law. So that's why I'm here. I'm very happy to be here as well.
Thank you, Alan. Uma, you're next on my screen.
Thanks a lot, Valerio, for having me part of this group, which sounds really very exciting. I'm Uma Rani. I'm a senior economist at the research department of the International Labour Organization. And I've been looking at this issue of gig economy since 2016, and I'd like to actually thank Valerio for actually bringing it to my notice as part of the RDW conference, and that's what got me interested to look at it much more from the development perspective. I think for me, one thing that I was struck at initially when I started looking at it is how close it is to home-based work that we knew from the developing economy context in a number of sectors. And I was very curious to understand how this work is being done and what does it mean. And my interest is not only with regard to looking at it from the working conditions of the workers and from the legal point of view, but also within the development context. What does this type of work mean, and how are platform business models actually precaritizing workers much more than before? Like, one of the arguments that is often brought in, and something we'll talk about tomorrow, is that platform businesses actually help to formalize work, but what we increasingly feel is that it precaritizes them more rather than formalizing them, especially within a developing country context. So my concerns are from there, and I'm trying to see how we can actually help to regulate the sector as we move forward. Thank you very much.
Thank you, Uma. Ruth, you are next on my screen.
Oh. Hi, everyone. I'm Ruth Jukes. I'm Professor of Labour Law at the University of Glasgow. I'm also delighted to be here. My interest in gig work is part of a project I've been doing the last few years, which has a broader focus. It's a project on work on demand. So together with the team of researchers I've been working on, that's the way we've treated gig work as one form of work on demand, of which there are various forms. And I'll be saying something about that later, I think. Thanks.
Thank you. Kelly?
Hi everyone, I'm Kelly Hausen. I'm a postdoctoral researcher on the Fair Work project at the Oxford Internet Institute. We're a kind of multidisciplinary project. My own background is in economic geography, but we are lucky to be part of a global collaborative network of researchers that is researching labour conditions across different sectors of the platform economy.
Thank you. Nastasia?
Hello, so thank you first of all for having me here. It's really a great pleasure to participate. I'm Nastasia Podolska-Sionek. I'm a PhD researcher at the European University Institute in Florence. I'm now in the final year of the PhD that is focusing on various regulatory aspects of platform work. From a global supply chains perspective, from temporary work agency perspective, and yeah, so.
Wonderful. Aude?
Hi, good afternoon, everyone. So my name is Aude Faliello. I'm a legal researcher at the European Trade Union Institute in the Health and Safety Unit. So my main angle is occupational health and safety, and it is how I approach the gig economy, and it's one of my research projects on the harsh and new form of work, and it's a chapter I will present with Christina this afternoon.
Thank you. Next I have Rishba.
Hello, my name is Rishabh, and I'm working with UMA at the International Labour Organization. I'm a research officer at the research department. I'm relatively new to the universe of research on platform economy. I have rather a background of research working with indigenous peoples and climate change, but it is something that I am gaining expertise slowly in, and it's very interesting for me, especially from the development side of things, the way Uma put it. It's also to better understand and demystify this belief that it is some sort of a silver bullet that can be used by developing countries. And working more and more with UMA, it's also been interesting to sort of delve more into the way workers engage with the platform and create spaces to sort of counter the processes that happen on platforms. So it's been interesting in that sense as well. And I'm looking forward to the discussions. Yeah.
Fantastic. Next I have Funda.
Hi, I'm Funda Stekspilda. I'm with Fair Work Foundation based at the Oxford Internet Institute as well with Kelly. I'm one of the postdoctoral students there. As Kelly mentioned, we are an interdisciplinary bunch. I'm a sociologist by training, and I have a background studying women's informal work in the developing world.
Thank you. Ricardo?
Yes, hello everyone. Sorry, I'm late. I had some problems with the internet. I'm actually here at the Max Planck Institute in Heidelberg at the moment, visiting, the Max Planck. But I'm a PhD student at the University of Bristol, having the privilege of writing with Alan, from the same university. But I'm actually from Chile. I'm a lawyer from Chile, and I'm interested in platform work. And in a similar fashion to Alan, I will say, in the theoretical foundations of labor law and how platform work teaches us, or pushes labor scholars to rethink the theoretical foundations of labor law, and the specific case of my biases on the European Union and how these changes are leading to normative changes within the European Union. Thank you.
Thank you. Yain?
Hello, everyone. I'm Ian Campbell. I'm here in Melbourne in Australia. I'm a sociologist by background, And my main area of interest is really casual work or casualized work arrangements in the mainstream of the economy, but I'm interested, of course, in platform work as insofar as and as it touches on that mainstream of casualized work.
Thank you. Alessio?
Yeah, hello. I'm a postdoctoral researcher at the Oxford Institute. I'm also interested, my background is in kind of social policy and kind of at the intersection between political economy and sociology of work. And I'm currently working on the Fair Work project, evaluating the kind of the working conditions offered by different digital platforms across the world.
Thank you. Alberto?
Hello. Hello, everyone. Sorry, okay, I hope that you can hear me. So my name is Alberto Barrio. I am currently a researcher at Leuven, although today is my last day of work, but I have been working as part of the Working Yet Poor project. And as part of that project, I also worked with Professor Paul Hawkins and Professor Elena Gramano, with which we brought this contribution. And my interest is in social security and platform work. I will also continue working about that after my position in Leuven. I am particularly interested in how platform work challenge the traditional elements of social security. We saw that, as in the case of non-standard work, that happened, but in the case of platform work, because it combines many different elements of different forms of non-standard work, some challenges result from the combination of these elements. And I have been doing research on this for the last 5 years, and I'm very looking forward to hear your opinions and also to interact with these other very interesting articles. Thank you very much.
Thank you, Alberto. Elena?
Hello, everyone. I guess we are introducing ourselves. My name is Elena Gramano. I'm assistant professor of labor law at Bocconi University in Milan. Today we'll be presenting on discrimination and artificial in general, and generally speaking, I research on labor law and new technologies, labor law and power dynamics, labor law and the contract, and so on, different fields of labor law, either at the European level and at the Italian level.
Thank you, Elena. Cristina?
Hello, everyone. I'm Cristina Inversi. I'm currently still a lecturer at the IMBS Manchester Business School, the University of Manchester, but I'm on an unpaid leave of 2 years to follow a project on exploitation in the agricultural sector of migrant workers. I did my PhD on the gig economy and the regulation of the gig economy, in particular the regulation of working time. And I did an empirical qualitative research on Deliveroo in the UK.
Then I have Nora.
Hello, everyone. My name is Nora Gülbel, and I'm also working at the International Labour Organization together with Uma Rani, and I'm working in her team and supporting the work that we are doing there.
Thank you, Nora. Then, Ilda, would you like to introduce yourself?
Yes, hello everyone. My name is Ilda. I'm at the last year of my PhD at the Institute for Labor Law of Leuven University. I'm doing my PhD under the supervision of Professor Valerio De Stefano, and the topic of my PhD is casual work and platform work, and how the casual work agenda can perhaps be extended to platform workers to ensure them with labor protection.
Thank you very much. Harry?
Hello, everybody. I'm just a PhD student as well in my last year. I'm doing my PhD on the human rights of self-employed workers with a special focus on platform workers. And I'm trying to assess whether a human rights-based approach can be one of the possible solutions to circumvent some of the practical as well as legal issues that the platform workers are facing. And of course, my main supervisor is Valerio. And together with Ilda and Matthias, we have also engaged in other projects.
Thank you, Harry. And Matthias?
Hello, everyone. I recently defended my PhD on the ILO's international labor standards and platform work, most notably homework, domestic work, and private employment agencies, with Valerio being my supervisor.
Thank you, Matthias. And I am Valerio De Stefano. I'm a professor of labor law at the University of Leuven. For now, starting next year, I will be moving to Canada and will get a position at Osgoode Hall Law School. I am generally interested in all things that have to do with technology and labor regulation. I've done research in the field of platform work and on artificial intelligence, especially at the workplace. Okay. I think we are done with our introduction roundtable, so we can proceed with the first panel. So we'll have two panels today. Between the two panels, we'll have a break. The two panels will work as this. Every speaker will present 3 papers or presentation per panel for 18-20 minutes. Then I would allow, and the chair will allow just clarification questions for after each of the paper, and then we will have a general discussion after the third paper is presented. So the first paper that we're gonna see today is a paper that Ilda, Ari, Matthias, and myself wrote on the employment status of platform workers. This is, of course, one of the things that has been most researched upon. We have recently written also a report for the ILO on this issue, and we wanted to kick off the meeting with this issue that has been so researched, to then proceed to other things that we feel need much more attention, at least in our field. So I think Ilda is going to do the presentation for the 4 of us, and Ilda, you have the floor when you are ready.
Yes, thank you, Valerio. I'm trying to open the presentation. I think the slides are preparing now. Okay, yeah. Okay, so I'm going to present today our book chapter in the book research agenda for the gig economy and society, and the title of our chapter is Exclusion by Default, Platform Workers' Quest for Labor Protections. First of all, a short outline of our book chapter. We have decided to structure it around 6 sections, starting with the introduction to the topic. Then we give the concept of the employment relationship through the lens of the ILO Employment Relationship Recommendation number 198. Afterwards, we go to the problem of employment classification, as it has been here before, and the concept of compound non-standard work. Section 4 is dedicated to platform workers' days in court, followed by some regulatory approaches to the labor protection of platform workers, and to conclude with some final remarks and future research agenda. So the questions: who is entitled to employment and labor protection, which workers are classified as employees, have a long history. As Davidoff, Friedland, and Kontouris have pointed out, they have been here like many centuries ago. So variations of these questions have been here even before the beginning of modern labor law. However, with the dawn of the gig economy, or what we call platform work, they have been put again in the spotlight. This is because platform workers experience a labor protection gap due to the consideration of platform companies, of them as independent contractors. However, according to many scholars, platform workers fall within the scope of existing employment and labor regulation. And an extensive body of case law, together with other measures taken by public authorities, can contribute to analyze this issue. On the concept of the employment relationship, through the lens of a recommendation, 2006 number 198 of the ILO. Under this instrument,
two potential conditions have been pointed out for the existence of the employment relationship, and these are subordination and dependence. And according to this instrument, member states have to clearly define these conditions. The recommendation provides for a list of indicators for subordination and dependence in its paragraph 13, and we have mentioned here only some of them. Not the whole list, such as the worker integration in the organization of the enterprise, personal work performed by the worker, work carried out within specific working hours, or at the workplace specified or agreed by the party requesting the work. All these indicators actually capture the features of a stereotypical standard employee in industry or commerce. But what about employees with workers which are different from the stereotypical standard employee? Actually, these workers have faced difficulties to find the existence of the employment relationship, such as starting with the example of workers in triangular work arrangements, where three parties are identified, such as the agency, worker, and the user enterprise. And it was difficult at the beginning to decide with whom to establish the existence of an employment relationship. Afterwards, at the EU and international level, it has been agreed that the relationship needs to be established between the agency and the worker. Same challenge for domestic and home workers whose place of work is different from the workplace of the employer. They face the same challenges. However, with the adoption of the ILO conventions, they were covered by labor and social protection in the same way as regular employees. The same is valid for workers in road transport, as they don't have a fixed workplace. And all these features we can find also in platform work. So platform work has multiple non-standard features together with a part-time work, temporary work, self-employed dimension. And that's what Eurofound considers compound non-standard work, a form of work which has multiple non-standard features. So due to these multiple non-standard features, it has been difficult for courts to figure out of platform workers' labor rights. However, on the other side, platform operators have taken advantage of these features by stating in their terms and conditions that platform workers are independent contractors and their role is merely as facilitators between workers and users. Since the mid-2010s, we have that many platform workers and other stakeholders have demanded a reclassification of their working arrangement. And an observation that we have made in our book chapter is that in almost all countries around the world, courts, and especially higher courts of some European countries, take issue with platform works being stripped of labor and social protection through their classification as independent contractors. And first, here we give the example of the Cour de Cassation in France, which took a decision in March 2020 that the relationship between the Uber driver and the platform was an employment one. However, later on, in January 2021, we have a lower court in France, the Court of Appeal in Lyon, which took a contradictory decision by deciding that Uber drivers are instead self-employed. In Italy, as well, we have a prominent decision of La Corte di Cassazione, which ruled that pursuant to a law enacted in 2015, all employment and labor legislation applies to workers whose work is organized by the other party, including platform, even if they do not meet the requirements to be classified as employees. Afterwards, we have a decision in November 2020 of a tribunal in Palermo, which decided that the global riders are employees, plain and simple, without the need for them to be classified as workers whose work is organized by another party, or what is called in Italy as lavoratore eteroorganizzato. The case of Spain, September 2020, there we have the Tribunal Supremo, which explained the notion of dependence in a more flexible way, and by saying that it does not imply simply absolute subordination, but only insertion into the organization of the company. And through this decision, it was acknowledged the emergence of digitalized control systems. In the UK, we have also a landmark decision from February 2021, where the court classified Uber drivers as limby workers, entitled to some basic labor protections, such as minimum wage rights, working time entitlements. However, later on, June 2021, the Court of Appeal concluded that Deliveroo bikers are in fact not employees, as they are in fact not in an employment relationship, as they have a genuine right to substitute themselves, by confirming in this way a previous decision taken by the Central Arbitration Committee in the UK for Deliveroo riders. To go on with some regulatory approaches to the labor protection of platform workers, we have divided them in two categories, some more general approaches and some more targeted ones for platform workers. Within the category of general approaches, we have put the AB5 law in California, which is now actually superseded by Proposition 22. According to this law, workers were to be legally presumed as employees unless the hiring entity shows that the three conditions of the ABC test are fulfilled. These conditions shortly are A, the person is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of work and in fact. B, the person performs work that is outside the usual course of the hiring entity business. And C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. Here, at general approaches, we have put as well the 2015 legislation in Italy, which you already mentioned. It was amended in 2019, according to which all employment and labor protection extend to workers whose work is organized by a third party, including a platform, even if they are self-employed, but unless a collective agreement says otherwise. And to go on with some more targeted approaches to platform workers, we have the recent Riders Law in Spain, which establishes a rebutable presumption of an employment relationship, but only for food delivery riders. And it also imposes the obligation for towards platform to make transparent the decision-making process of algorithms, which impacts the working conditions of workers, access and termination of their relationship with a platform. Here we have as well the EU regulation 2019 on promoting fairness and transparency for business user of online intermediation services. However, this regulation only provides some protection, but only for self-employed platform workers, which is the case also in Spain. On the other side, we have identified some countries which have taken initiatives actually to restrict platform workers' odds to obtain employment rights, aiming instead to promote entrepreneurship, but some of these initiatives were quashed by national constitutional courts. And to conclude with some final remarks here concerning case law. As we saw, more and more courts are willing now to accept platform workers that they fall within the scope of existing labor and employment protection. These rulings have largely dismissed the business clauses, which state that platform workers are self-employed, the flexibility of working time, and the right to be substituted by another worker in the determination of the employment status. Instead, what this court have recognized is control through digital tools, which has become even more effective than the traditional one. Concerning regulatory approaches, we notice the lack of a generalized legislative response on a transnational level so far. And this is also because legal solutions in the field of employment status cannot be simply transposed by countries, as each country has its own peculiarities and needs to develop its own strategies to embed platform work into existing labor law frameworks satisfactorily. And to conclude with some recommendations with the future research agenda, we recommend that future research may be wanted in particular to study the extent to which case law about platform work reflects already existing developments or is in fact shaping laws on employment relationship at large. it's necessary to assess the efficiency of these legislative measures that we just mentioned, like the Californian ABC test, the Italian statute, or the Spanish presumption, in permanently solving the misclassification issue, and if they have any undesirable effect as well. It may want it as well to be analyzed whether online crowd work can be legally captured under existing regulations, or maybe it requires new regulatory frameworks. And to conclude with, it may be necessary to test whether the contract of employment is still the key gateway to protection, or whether other approaches, such as the personal work approach, are necessary to embrace these forms of work. And that was it from my side. I would like to thank you very much for your attention.
Thank you, Ilda, also for being on time. I would open the floor only for clarification questions, if there are any at some point, at this point, or we can discuss the paper more broadly during the discussion. Okay, so if there's no clarification question, I now give the floor to Alessio, Funda, and Kelly. They have written a chapter on the geographies of platform work. We think that this is something that needs to be brought to the attention of the broader labor law and labor scholarship. There are some aspects that are connected to economic geography that are extremely relevant in platform work, and I'm very much looking forward to hear from them. So please, you have the floor.
Thanks. Can you all see the screen? Because I've just shared it, so hopefully it will work. Cool. Thanks, Valerio. So as you already said, I've written this chapter together with my colleagues Kelly, Surjana, Funda, and Mark, and we're all part of the Fair Work project based out of Oxford Institute. So just to give you a brief outline of the presentation, first of all, I will discuss how platforms interact with the spatial dynamics of labor and help kind of shaping new dynamics to spatial dynamics of labor. Then we'll try to define our research agenda for economic and specifically labor geographies. And I will illustrate the agenda through examples of multiscalar counter movements. It sounds quite a complicated term, but after the end of the presentation, probably will be clear what we mean by those. And I will try to conclude with some key arguments and key lessons we can draw from this. So just a bit of an introduction, like how are digital platforms seen in economic geography? Well, platforms operate at different spatial levels, the local, the regional, and the global. However, they don't operate at each spatial level in the same way, and they are generally been argued by geographers to interact with different levels in a tactical way. By tactical way, I mean they can engage and disengage with each level in order to pursue their own interests. I mean, a clear example is the avoidance of local and national obligations when it comes to employment rights and labor rights, despite the fact that they operate in a certain jurisdiction, in a certain labor market. And so this kind of tactical way of interacting and in the spatial level has been argued to produce so-called disembedding tendencies in the spatial context, because although the platforms are on the one hand very much integrated, very much embedded in the local labor market, they also present characteristics and features they make them not relate with some aspects of the local context. And in that sense, platforms can be said to shape relational global networks in different sectors, and they connect workers to global supply chains and global value creation and value extractions network in all the sectors in which they are operating. And by shaping these relational global nexus, they also affect the distribution of agency, power, and capital accumulation vis-a-vis workers. And so what we argue in this paper is it's important for geographers to understand how these platforms interact and shape or reshape the spatial dynamics of level at different scales. So as already been said by the previous presentation by Ilda, platforms use different techniques, in a sense, to avoid labor regulations, and they have been argued to foster the commodification of labor on a global level, and also to undermine labor standards at different spatial scales. And I won't go into much detail about this. We all know what are the main issues associated with platform work, such as employment misclassification, the fact that workers are paid mostly on a piece rate, the fact there is a lot of competitions between worker, algorithmic management, but also the reliance on a already quite marginalized workforce in the vast majority of countries, both in the global north and in the global south. The vast majority of workers are either from an immigrant background or from an ethnic minority. So what we argue in this chapter is actually it's fundamental for research to understand how possible counter movements can counteract these processes of disembedding. I don't know why I cannot move it anymore. Great. So what are these colors, a multi-scalar counter movement? Well, what we argue is actually in order to re-embed platforms into the local and the national context, counter movement have to act at the different spatial scales in which platforms operate. And in this chapter, we identified 4 types of counter movements: worker resistance, online tools, national regulation, and international and civil society organization. And I will now discuss each one in turn. So, I mean, essentially, there's quite a lot of literature and a developing literature on the topic, but basically pay, poor working conditions, automated management, and health and safety risks have been regarded in the literature as the key reasons for worker resistance. And of course, the COVID pandemic has basically exacerbated these pre-existing risks. So these risks were already there, but of course, the fact that like many gig workers, especially in the food delivery and delivery sector, have been at the forefront of the crisis, and they had a very high risk of contracting the virus, and at the same time, a very little financial or social protections in case they had to self-isolate or to quarantine because of COVID, has shown how vulnerable these workers are compared to other workers. And for these reasons, workers have mobilized and coordinated collective actions in different jurisdictions. And what we're focusing here specifically in how these collective actions have been coordinated either at the national or the transnational and international level. And I think a good example of this are the Latin American protests that sparked around Latin America last year, mostly in Brazil, Mexico, Chile, Argentina, and Ecuador. This was the period basically in the spring and summer of last year. If you remember, there was still the first wave of COVID. It was the period of kind of strictest lockdown in most countries across the world. And these workers felt they really had to go on the square and really join together forces at the transnational level in order to organize and protest against the poor working conditions, the little securities that these platforms were giving to them. And social media here were shown to be a very key tool, a very relevant tool to organize and coordinate resistance across borders. And we'll discuss social media also in a minute in the context of online tools. But aside from coordination of mobilization across countries, what we've seen is that during the COVID pandemic, also international and cross-national organizations and workers' associations have also joined forces at both the national and the international level. And among the more prominent are the Indian Federation of App-Based Transport Workers that was created to coordinate actions and protests across different cities and different states in India. You always have to consider, India is a huge country with more than 1.4 billion people with many different languages, many different cultures. So the fact that there is an Indian federation that is able to coordinate these actions across different language barriers and cultural barriers is, we think, a prominent example of actions at a different scales rather than the local one. But there are also other initiatives. In January 2020 in the UK, there was the first meeting between 25 unions and worker organizations representing app-based transport workers, and they have committed to work as a loose federation to protect and foster workers' rights. And another example is this Transnational Federation of Couriers. In this case, it mostly focuses on food delivery and delivery drivers, mostly in European countries, and again, is an association for unions and workers representation organization trying to coordinate collective actions at the European level. But we also know that rating systems and algorithmic management engender an asymmetry of information between, on the one hand, an almost all-knowing platform which is able to control and monitor workers' performance and workers' labor from a distance, and a worker that sometimes doesn't have even the most basic information about how pay is calculated, how the route to work is calculated, and many other important dimensions of their labor. And of course, this asymmetry of information fosters an imbalance of power between platforms and workers. And what we argue here is actually online tools can help rebalance this relationship. And here we present three main examples of online tools. There is the very famous Turkopticon. So Turkopticon, for those of you who are not familiar with it, is a browser extension that was developed in 2008 for Amazon Mechanical Turk. Amazon Mechanical Turk is by far the largest cloud work platform globally. And before the creation of Turkopticon, workers working for Amazon Mechanical Turk had basically no information about the requesters of tasks, but the requester had plenty of information through ratings and review about the workers. So what Turkopticon does is basically providing a more symmetry in the information by allowing workers to rate their requester based on a number of dimensions that you can see here in the little image, but also to provide qualitative reviews of the requester. And in this way, it can also help workers to make more informed choices about their work they accept or not. And another good example is the app WeClock that was developed by the Uni Global in collaboration with universities and non-profit organizations. And because of algorithm management, many workers don't have a clear understanding of how their working time or how their pay is calculated. And the app WeClock helps, again, workers make their own calculation, therefore offers more evidence through which worker can also, in a sense, contest and the platform's decision. And again, as I was saying before, with the example of the Latin American strike, social media play also a relevant role. In the platform economy, many workers work in isolation. In some sectors, such as domestic work, they have little or no opportunity to meet with other workers from the same platform. So online tools such as social media like WhatsApp, Facebook, or also Reddit can really provide a platform through which workers can help each other, build solidarity, but also organize and coordinate collective action. And Ilda discussed this in much more detail in the previous presentations, but of course, platforms often operate in an uncharted legal and regulatory territory. And as I was saying at the beginning, they are able, by engaging and disengaging with local regulations as they please, they're also able to avoid many of the obligations and many of the responsibilities that normal employers and normal companies have. But regulatory and legal authorities have started addressing these legal and regulatory gaps. So I won't go into much detail about this because Ilda has discussed this in much more detail, but basically several court cases around the world have started addressing some of the issues, in particular the issue of misclassification and the issue of algorithmic management. But also legislations across the world have also started, at least have initiated a process of employment and labor law reform. The most recent example is the Riders Law that came into effect a couple of months ago in Spain. And of course, most of these employment and labor law reform concern so-called geographically tethered or location-based platform workers, there's much less protection and much less legislative initiative when it comes to cloud work platform. And the reason for this is, of course, it's much more difficult to regulate cloud workers, because although the company might be set up in a certain countries, workers might be working from many different locations and in many different jurisdictions. However, there are also some more positive and optimistic signals. Some countries, such as Germany, for example, have recently implemented the law on supply chain due diligence. And these act where basically they oblige multinational firms who are headquartered in Germany to respect human rights across their supply chain. So laws and legislative initiatives of this kind can also provide an interesting template for also regulating platforms which operate across national borders. And of course, platforms are multinational cooperation, and as I said already multiple times, they are able to bypass national borders when it comes to regulations. So international organization can help and can provide an interesting kind of template and can help clarify some of the gray areas at the national and the local level, and at the same time identify the best practice that member countries could follow. And the ILO, what we think is the most relevant initiative so far is the Decent Work Agenda that was proposed a few years ago. And although it's not specifically focused on platform work, it includes basically all workers. It refers to all workers regardless of employment status. And it's meant to provide decent, fair, and inclusive work for everybody in the world by 2030. And it was later embedded in the United Nations Sustainable Development Goals, and it was also used as an action point and in kind of like formal statement by the G7, the G20, and also by the African Union. However, at the time of speaking, there's no existing ILO convention so far specifically on platform work, but with some colleagues at Fair Work, we have now just published a paper on what a possible content for an ILO convention on platform work could be. And of course, the EU is a very special kind of international organizations, and has already implemented, as was said in the previous presentation, some regulations that to some extent affect the rights of platform workers in the EU. But also the EU Commission have recently started a regulatory initiative on platform work just this year in 2021. And it has now terminated the second round of consultation just a couple of weeks ago. And the European Commission is expected to have and create propose like a legislative proposal by the end of this year. It's still very uncertain what the content exactly will be, but it might be the first legally binding legislative initiative at the supranational level as concerning platform work. But of course, intergovernmental and supranational organizations are not the only organization that can affect the regulation and can help re-embedding platforms into the national and local level. And academic and civil society organizations can also contribute and promote transparency and accountability and responsibility, I would also add, to platforms across the world. And for example, the World Fair Trade Organization has recently certified the first fair trade platforms. There's a platform in Kenya called Digital Lions, and hopefully more will come in the incoming months and year. But also our current project Fair Work, which evaluates the working conditions offered by digital platforms across 25 countries. We're still expanding as well, can also provide a system of checks and balance for platforms and pushing for more accountable and more responsible working models. So in conclusion, platforms have been able to operate at different geographical scales in a very tactical way, and therefore have been able to avoid some important obligations when it comes to workers' rights and labor standards. And the process of platformization has, in a sense, accelerated the commodification of labor and undermined labor standards across the world. However, what we wanted to highlight as a research agenda for labor geographer is that multiscalar movement can help counteract these disembedding tendencies and, in a sense, can help re-embed the platform economy into local and national context. Thanks a lot.
Thank you, Alessio. We are really right on time, which is already something, given that there is an Italian chairing the session. So I would want to open if there's any clarification points at this moment. Otherwise, we will have the discussion later on, also on the second paper. And now for the third paper of this initial session, Elena Gramano, who has been writing a chapter together with Miriam Kuhlman at the Free University in Amsterdam. Elena is based at Bocconi University, of course. This paper is going to focus on algorithmic discrimination as it relates to platform workers, but I guess also a bit broader than that. Elena, you have the floor. Thank you very much.
Thank you, Valerio, and thank you, Valerio, Ilda, Henry, and Matthias for the invitation. As you anticipated, I will be speaking today also on behalf of my co-author and friend, Miriam Kuhlman from the University of Amsterdam, who couldn't be here. We open our chapter with an almost obvious observation shared by most of the legal scholars, at least in the labor law field, and that was actually anticipated by Ilda in her presentation at the beginning of our webinar. Basically, with the advent of gig economy, work relations have undergone a deep change. Gig work, with its fragmented work patterns and its shift from paper hour to paper task, most prominently features two related legal issues. First, and most prominently, the challenge to the existing legal notions of employee or employer, which was already covered. I'm not going to add anything to that. And secondly, it forces us on us some reflections on the role and power dynamics and legal consequences of the use of what has become known as algorithmic management, with platform or gig companies using artificial intelligence, or more specifically algorithms, to manage their workforce and the organization of the workforce. It is here where the question raises whether, and if so, to what extent, the employer, or at least the entity that takes advantage of this technology, not directly but rather by means of those technologies, is able to give instructions and is able to determine, for example, who will be offered the next gig, how those gigs will be distributed among available workers, and eventually also who could be removed from the workforce altogether, what we will call in legal terms dismissal. Yet it is in this particular step where the question on discrimination comes up. In the organization, access to work via the platform. We can affirm, but of course I'm open to hear your observation about this, but at least in our opinion, we can affirm that somehow it is clear from a legal point of view that the ultimate legal responsibility for the management of the workforce relies entirely on the employer, or if we want to keep it more general, relies entirely on the entity, on the subject that takes advantage of the working activity and on the technologies used thereof. And we can also all agree that limits to the typical employer's prerogatives must be put into place and properly enforced in order to safeguard freedom, dignity, personality, and the economic, social, and personal rights of the workers. That given, though, it is also true, and we can observe that the advent of the use of algorithms blurs the boundaries of the legal liability of those companies, usually platforms, that take advantage of algorithms and artificial intelligence to manage workers. Somehow, algorithms shelter employers from the direct contact with the workers and therefore make it more difficult to verify, to ascertain the lawfulness of the outcomes of algorithms themselves on the workers, and also to ascertain, to see the true dynamics that occur behind the curtains of what is often presented or appears as a neutral artificial systems where human interactions are reduced to the very minimum. We do know that over the past years, and Alessio also reminded that of us, and Ilda as well, several courts were asked under different jurisdictions to ascertain the legal classification of the working relationship between platforms and workers. What is relatively new, and I believe also of absolute interest, is that more recently courts have been addressed also with questions related to the specific function of algorithms in the management of the workforce, and in particular on the discriminatory potential of algorithms that platforms employ to manage the workforce. Such cases are rich of implications, both at the national and supranational European level, and we believe they might be of absolute help in building a research agenda on this matter, on algorithm discrimination. This is why in our chapter, me and Miriam draw some reflections from two national cases, an Italian one and the Dutch one, which is funny because I am Italian and Miriam is almost Dutch, at least absolutely fluent in Dutch and based in a Dutch university. And we draw from these two cases to illustrate both discrimination through algorithm decision making and the role of EU non-discrimination law in protecting platform workers, or rather maybe not. As I anticipated, the first case is an Italian one decided by the Tribunal of Bologna on the 31st December 2020, and the second case was decided by the Amsterdam Appeal Courts in the Netherlands in February 2021. And interestingly enough, both decisions involve a very well-known food delivery platform named Deliveroo, and in particular the use of a certain algorithm that is named Frank. I'm not going into the details of the two cases in my presentation today. Of course, I'm more than available to answer any question about them, but I hope you could have a glance at our chapter that Valerio circulated already. Instead, I like to anticipate, for the purpose of our discussion today, the main focus of our chapter and the reflections that we try to build to elaborate on the base of those cases. Of course, we do know that the topic of discrimination by means of algorithms is a topic that has been under the attention of the legal doctrine already for some time now. However, we try to enrich the current state of the art on the matter and to build a future research agenda exactly by trying to understand the concrete implications and issues involved in the mentioned case, a sort of, let's say, practical approach in understanding the real use made of the existing legal sources by two national courts in addressing such a matter. And by comparing the two cases, analyzing the two cases, reading the reasoning that the judges built in those cases, we elaborate a number of observations that I'm gonna list now. First of all, we ask ourselves a question on the suitability of the grounds named by the law to define discrimination. We do know, I'm not going to go into details about this, those are all well-known aspects of the, at least European anti-discrimination law, but we do know that anti-discrimination law relates to a number of grounds of discrimination that are named by the law. Of course, they are broadly interpreted by cases, in particular by the case law of the Court of Justice of the European Union, for example, but still they are related to a defined number of discrimination grounds. The Court of Justice of the European Union had already the opportunity to include within the notion of discrimination also the so-called discrimination per proxy. And well known is, for example, the linkage built by the Court of Justice between discrimination due to pregnancy or maternity and discrimination on the basis of sex. But moreover, we understand that the use of artificial intelligence and algorithms, the spheres that create more concerns in terms of protection against discriminations are usually exactly those between or on the line among or between different name grounds of discrimination. And therefore, the role of proxy discrimination and its interpretation from a legal point of view is now more essential than ever. Second point that we try to address, and that was already anticipated by Alessio, a matter that is relevant also from a legal point of view is the complexity and therefore the opacity of the functioning of the algorithms and their systems. In both cases that we had the chance to analyze, courts struggle understanding the real mechanisms at the bottom of the algorithmic trunk used by Deliveroo. And this raises a number of important questions that we believe a research agenda on the topic shall include. How was the algorithm actually designed? Was it tailored, for example, for the Italian or rather the Dutch market? Which data were processed and according to which kind of reasoning? If a certain algorithm is considered as discriminatory under a certain legal system, what are the potential, if any, spillover effects in other European member states? Third, I'm going fast, but just to give you an overview of our chapter. Third, we try to reflect on the quality, not only the quantity, but also the quality of the data used for and by the algorithm. For the algorithm to work in the way the company wants, desires, selecting criteria are being matched with data with which the algorithm is then being trained, tested, and then deployed. It is interesting that, and of course, I'm going to be brief, but I think we all know that through some data that can be collected by the algorithm, we can infer other data. For example, if I'm able to locate exactly my worker, I might be able to understand where she lives, maybe what is her social background, if she's a student or a full-time worker, whether she lives in a certain neighborhood or another one. And that in certain areas might also lead me to understand what is her racial background, maybe her religion, and so on and so forth. High data quality appears to be a main concern also if we have a look at the Artificial Intelligence Proposal Act that links in recital 44 contains a link to Article 9 of the GDPR that refers to data that are highly sensitive in terms of being able to show and share certain personal aspects of the person. And of course, this is another matter that we need to investigate when addressing the problem of discrimination and the quality of the data that an algorithm is able to collect and to process. Finally, and I take the next 5 minutes to conclude, we try to build some reflections on the matter of enforcement and the role of trade unions. On the matter of enforcement, we shall admit that at least at European level, anti-discrimination law was quite thinking forward already. For example, by assessing that there is a reverse burden of proof between the employer and the employee, or the potential discriminatory part and the victim of the discrimination. And furthermore, when assessing that we don't really need to investigate on the will or the intention to discriminate, but what is enough is the effect produced on the victim or potential victims of the discrimination. And this was essential, for example, in the Italian case, where the judge was not really able to understand how the algorithm actually worked, but was able to understand that discriminatory effects were nevertheless produced. So we have already some good, let's say, positive, effective instruments implemented by the law already. But apart from that, we believe, and those cases that we analyze, which were brought before courts exactly by trade unions, we believe that a special role shall be granted, recognized, and meaningfully implemented also for workers' representatives, generally speaking. That is for many reasons. First of all, single individual workers might not be even in a position of understanding that they are being discriminated against, or to which extent they are being discriminated against, while worker representatives or trade unions might have a better understanding of the overall systems, given the fact that the algorithm reproduces the same decision patterns on a large scale. Secondly, trade unions, worker representatives, generally speaking, might have the means to react against discrimination when detected. However, there are still some open issues, and I'll conclude here. First of all, through the legal system, the legal means that we have at the moment, we are able to act only when the discriminatory effect has already been produced. We need to wait till the end of the process to understand whether there has been discrimination. And that is not easy in any case, but we need to wait for the process to be over. While an effective way to prevent discrimination will be to understand and monitor the process in itself, to tackle the opacity, the lack of transparency of the process, the understanding of the data and the decision patterns actually implemented through and used by the algorithm. There is another open issue. Of course, we can all support the idea that a collective dimension in the management and understanding and monitoring of the algorithms and the decision-making process implemented by them is useful, actually essential. But, and here I come back to the original question posed by at the beginning of our webinar, in many cases, platform workers are not organized, collectively organized. In some cases, they're not even entitled to exercise their fundamental collective rights as they are linked to the status of employee. So we need, of course, in most cases, to fill the previous gap, meaning the recognition of their status of employee, or on the other hand, we need to enlarge the scope of application of existing laws in order to include also those workers who might not fall exactly within the notion of employee. Those are all aspects that are left ignored by the Artificial Intelligence Act proposal. And this is, and I conclude here, I believe symptomatic of the fact that the lawmaker is ignoring the fact that we need to adopt a different specific approach when regulating the use of artificial intelligence in working relationship, in work-related dimensions, their specific power dynamics, and the specific needs that a work relationship rise. Thank you for your attention.
Thank you, Elena. Are there any clarification questions for Elena? I don't think so, so I would open the floor for the general discussion of the 3 papers. Aude, please.
Hi, thank you for the 3 groups for this really fascinating papers and presentation. I have 2 main remarks and questions. So I think it's Alessio who mentioned the EU initiative at the moment about, what is the title exactly? Possible action addressing the challenges related to working conditions in platform work. And actually one of the main discussion with the social partners is the possibility to have a presumption of employability with a reversal burden of proof. So we have no guarantee that that's going to happen. We'll see that in December. But if it is the case, so that was my question for Ilda and the first group, I don't know when we have to submit the final draft of the chapters, but I think it would be interesting to maybe take that in consideration, depending if there is space for this, because that can be maybe an actual game changer and give the full power to all the cases and all the judicial recodification that we have seen, and finally reaching a structural change. And actually, like Alessio and his group, do you think that this presumption and reversal burden of proof might address a bit some, I don't know how to say that, unicity in the geographical scope, and finally we'll have a common base and it can address some challenges that you raised, or not at all? And then quickly for Elena and Miriam about the AI Act, which is still also a work in progress. And I fully support you in the fact that that should be different for employment relationship, but do you think that the obligation of transparency and the fact that they should keep the logs and all of this for providers and users can still be used as a leverage in front of courts, even if we can be really critical of the quality of this provision? Do you think it's still something that can help a bit your case? Thank you very much.
Thank you, Aude. I have Ruth and then Alan. I will take these 3 questions first, and then we'll reopen the floor. Ruth, please.
Thanks, Valerio, and thanks for 3 great papers. My question's for Ilda and the first group, because you said that you begin with the ILO recommendation, and of course the ILO recommendation places a lot of weight on what we might call the reality of the relationship over the terms of the contract. Now, I can't pretend to know the case law outside of the UK at all well, but from a knowledge of the UK case law and from being in the UK looking outwards, it would seem to me that this is a kind of important question when it comes to comparing approaches in different jurisdictions, how much weight is given to the contract and how much is given to other things. So I wonder, do you use that in your paper as a way of distinguishing different approaches between jurisdictions?
Thank you, Ruth. Alan.
Thanks very much for 3 sort of fabulous papers, and all of them really stimulating and great to listen to. My question is specifically for the first paper given by Ilda, and it's really a question about the personal work concept as a proposal for reconfiguring employment status in the gig economy. So I know this is a kind of proposal that's got some traction now. I think Valerio and Nicola Conturius have written in defense of this. And the question I have is, how does that fit with the difficulties in the UK context around substitution clauses? So if you place emphasis in a revised test on predominantly personal work, and then you look at the Deliveroo decision in the UK, the difficulty that we now have in the UK is that where you have a non-sham substitution clause, at the current time, that seems to create very, very serious difficulties for gig workers where there is a substitution clause in the contract. So the question really is, why give so much weight to the personal work dimension if it's going to effectively invite contractual circumvention through substitution clauses? And are there any ways that you think that we might address that difficulty if we do go down the personal work route?
Thank you, Alan. I think I can take this last question, because that's the personal work approach is really my addition to the paper, and then I will leave Ilda answer to the rest of the question for the paper. Definitely, the substitution clauses present a problem for the personal scope in a jurisdiction such as the United Kingdom. I think, though, the most of the problems lie with the idea that the courts really don't look that much into to what extent those clauses are effective and used. If you look how possible it is for riders to be regularly substituted by other workers, those possibilities are minimal. It might be that sometimes it happens that a worker is able to have themselves substituted, but there are also some ways of actually questioning the insertion of the substitution clauses. Why would you want the substitution clause if you say that the algorithm doesn't penalize you when you don't answer calls, when you don't show up? There is a contradiction between the terms of the contract, between those clauses and the practices that all riders report, that if they don't show up at certain shifts or after they have booked for a shift, basically they get penalized. So going back to, and then I really leave Ilda answer to those other questions, but there's a problem, in my opinion, when I've read those decisions in the UK. In my opinion, there's a problem of primacy of facts, that actually the courts doesn't really look into the reality of the relationship. Having said that, I am aware, and I think also Nicola is aware of the fact that substitution clauses pose a real problem when they are non-sham to the personal work approach, and definitely this is something that we will need to work on. But I think the same problem is posed if we are still looking at the UK to employment status and even to Lim B status. So it's not that the existing situation is any way better than what personal work could get, but definitely this is a problem also for the personal work approach. I'm pretty much aware of that. I'm sorry, so I think there are questions for all the papers. Alessio, you want to start?
Yeah, I can start answering Aude's question. In a sense, so I'm not a lawyer, so I might not be the best person. I know there are a lot of lawyers in the room, so I don't feel qualified enough probably to answer this question. But in my opinion, actually that of my colleagues, what we've seen is, of course, like the presumption of employee status would be a positive development. At the same time, like, in a sense, we don't think is the main thing that should really change, you know, like without enforcement and proper inspections, that, you know, like the change in the presumption doesn't really change. So what I think what should really change is workers shouldn't be obliged to rely on courts and bring these platforms to court, so that the law should operate at an earlier stage. I think that would be what would really be important. But of course, you know, everything that could help rebalancing the power between the platforms and the workers is of course welcome.
Thank you, Alessio. Ilda?
Okay, I will try to answer the second question about the reality of the relationship and how much weight is being given to contracts in different jurisdictions. An observation that we have made in our book chapter is that now courts are more and more looking at this reality of the relationships. They are going like beyond the business clauses inserted by platforms, which may actually express just the platform wishes. And yeah, so courts emphasize more and more that all elements need to be taken into consideration, the indicators of subordination and dependence that I mentioned, and they go beyond these clauses, they go beyond simply they go beyond the flexibility myth which has been proclaimed by platforms, and yeah, that's it. Matthias, if you want to answer to the first one.
About the first question, it's a very difficult one to answer because it's a bit looking into the future, but I am at least very interested to see what will happen at an EU level if you want to come up with a presumption, because there are millions, there are 100 versions of a presumption that you could think of. So to some extent, you could say journalists are all employees, and you could do the same for platform workers are all employees. But in the end, if you look at the entire spectrum of platform workers, some of them are probably genuinely self-employed. So on the other hand, you could also do a more targeted approach, which is, for instance, what happened in Spain, where you focus on Deliveroo, bikers, or other food delivery platforms. But even in such a case, based on the national law that already exists, the presumption can also be a kind of a toxic gift, in the sense that if the Supreme Court says that these are all workers covered by labor law, then to introduce a presumption kind of gives a contrary indication, making it seem as if that is still a question that is up for debate, even if Supreme Court might have judged it clear that these are employees or workers covered under another status. So presumptions can work in all directions, and they can definitely have their use in a specific situation. But since EU member states are so different, I wonder what such a presumption would look like at an EU level.
Can I add something on this about the presumptions? Just because it's the question. But just from our experience, like the two presumptions example that we are giving in our paper, for instance, the AB5 law in California and the writer's law in Spain, like in both of the situations, we cannot really assess whether the presumptions at the end of the day, they're going to be beneficial for workers, but both of these presumptions, they have created a kind of reaction from platforms. You see in California, for instance, what happened with the Proposition 22 and the writer's law that also creates a presumption in Spain. Many platforms until now, they have kind of threatened that they are leaving the country, like Glovo, for instance. So until now, these two examples indicate at least that platforms can be really annoyed by this kind of presumptions wherever they exist. So this is a generic comment as well,
Thank you, Ari. Elena?
Well, thank you for your question. I guess that the European lawmaker is absolutely well aware, as we all are, that one of the problems of algorithms stays in their opacity, and that is explicitly stated all over the proposal. I'm not sure whether such an obligation of transparency is enough, as stated in the proposal, because of course, but I mean, I believe I'm not saying anything new. The problem is then the actual implementation and enforcement of this transparency obligation. In reading the cases that me and Miriam analyze in our chapter, it is interesting to see that judges were able somehow to circumvent. They acknowledge the lack of transparency. They acknowledge the fact that most probably Deliveroo decided not to share a number of information, even during the procedure, the judicial procedure, maybe not to share some information they didn't want the public to know about. But judges were able to circumvent such limitations basically by strictly applying anti-discrimination law that, as I said, focus exclusively on the effects rather than on the subjective decision of the discriminatory party.
Thanks a lot, Elena. Ricardo, I see you have your hand raised.
Yeah, thank you. Yeah, I just have a very short comment for Ilda and the others. And I read your work and I think it's very interesting. However, I was wondering if you can elaborate a bit more on the idea of what's a standard employment relationship. I know this is very tricky, and I know this might be a lot of work, but I think your work will benefit if you briefly explain what do you mean by standard employment relationship, because this will show the big contrast between what we think or what we thought work has always been or was, and what work has become. I think that will be interesting. And I also wanted to say something to Alan on the personal scope. I think that's a very interesting question. And I'm doing my PhD in the UK, but I come from a civil law background. And every time I engage in conversations with Brits on the personal scope and the substitution clause, I'm always thinking, but this is not an issue in Latin America, at least. Because we are applying different labor standards, and I don't know, for example, a substitution clause is overrun or replaced by human rights standards. So like Valerio was saying, we are, in Latin America at least, not forced to look at the contract. Instead, we are very much used to look at the reality of the work relationship. So a substitution clause will not be really a problem. But of course, again, living in the UK for many years, I see why this is a problem in the UK. So I think this is a very interesting contrast that I'm not really sure if it's happening in continental Europe, but this is definitely something I can see from Latin America and the UK. Thank you.
Thank you, Ricardo. And I think answering to this point on the standard employment relationship, indeed, our approach is to compare, or basically to put together the employment relationship recommendation of the ILO and the issue of platform work, rather than looking more broadly at the literature on standard employment, on the ICR, on the standard employment relationship, because otherwise we would have to deepen other aspects, including how much these forms of work differentiate from temporary agency work, from fixed term contracts, which is something that we have done in other parts of our research. But it's for the chapter, it would be just too broad. So the focus is on the employment relationship recommendation. And I think something that I would like also to hear from the others, and particularly from people who are based in the UK. But one of the issues of the employment relationship recommendation, probably one of the, besides the political points that made not possible to reach a convention on that point, is actually the fact that civil law and common law have a completely different approach to the contractual terms and conditions. In many civil law countries, yes, court can pay lip service to the idea that they should also look at the clauses, but if they see something that is not really consistent with the clauses, they are very ready to disregard what the content of the clauses are. If I understand correctly, this is not what happens in the UK. This is not what happened. I mean, of course, you can go beyond the terms and conditions, but to completely disregard what these terms and conditions say would not be in the courts of the UK courts. I'm not sure if the people who are based in the UK agree on this. No? Alan, and then Nathan.
So I'm pretty sure I'm going to at least disagree with Ruth, because I could see our heads were nodding on different axes on this point. So I mean, my reading of Uber would be that it's actually a radical decision. It's very much rooted in a kind of anti-contracting out principle that's embedded in the statute. Listen, this is it's only just been handed down, and it's going to take time to see how it's going to develop. My view of Uber is that if you focus on the kind of anti-contracting out argument, which is certainly there in one of the paragraphs in Lord Tulson's judgment, that I think does provide a foothold for the argument that this is actually more closely aligned with the civilian approach that you've just described. And I think one of the kind of oddities of Deliveroo is that Deliveroo was handed down after the Uber decision had been published. So I think the Court of Appeal heard argument very briefly on Uber after the first hearing and before they gave judgment, but certainly not enough for Uber to have any real impact on Deliveroo. And for what it's worth, my view of Deliveroo is that if it were being argued today and the argument was focused on applying Uber to the facts in Deliveroo, I have absolutely no doubt that Deliveroo would be decided in the other way. And I'll tell you why. Because the substitution clause in Deliveroo was inserted by the lawyers in a new set of contracts days before the Central Arbitration Committee hearing. So, I mean, there was no doubt that the substitution clause, even though it was valid, it was not a sham, it was there deliberately to exclude the statutory protection. And my reading of Uber would be that Uber would now cover that situation. But, you know, that's my view, and I think other people might take a more limited view of the potential of that judgment.
Thank you, Alan. Ruth, do you want to say something about this, or?
Not very much. I mean, obviously, normatively, I'm totally with Alan. I mean, I think that's a very nice reading of Uber, and if that's the way that it goes, great. But I think there is this massive hurdle to be got over, which is that all of the statutes direct the are framed. The definition of whether someone's an employee or a LIMBY worker is framed with reference to the contract. You can't get away from that. That's what they say, you know. So that's the hurdle. The courts or whoever are directed to look first and foremost at the contract by the statute directs them to do so.
Christina, please.
Yes, so, well, my reading from a civil law perspective as well, having like worked on the Uber and, well, mostly on the Deliveroo decision, is that, I mean, the essential difference with like a civil law approach is that it's just the possibility of having a genuine substitution. So it's not if it actually ever happened, but it would be like what an Italian court will be looking for, but actually that it is written in the contract and it's actually possible. And yes, what happened in the Deliveroo case is that, well, the Deliveroo lawyers really looked well at the previous previous decisions, also the Pimlico Plumbers decision, and reshaped the clause in a way that was actually impossible for the court to say, well, it could not happen or it never happened. So I think that is the slight difference between like a civil court approach and a common law approach in the UK.
Thank you, Cristina. Riccardo, if your question or comment is still on this, I would like to go on to ask questions on the other papers, if you allow.
Sorry, I just wanted to discuss a bit more on this, so that's fine. You carry on. It's okay.
I think we're gonna go back on this anyway, also when we'll be discussing your paper. So I think we can save for that. But I would like to ask a question to Alessio and one to Elena. To Alessio, I see that your paper puts together, if you want, the online platforms and the offline platforms. As a lawyer, I'm curious to know what geographers see as point of similarities between the online and offline, and what are the main differences that they see on the two families of platform. And to Elena, I have a question that is about the role of the judges in understanding the discrimination. You say that the Bologna court didn't really know what the algorithm was doing, but they felt that the algorithm was discriminating against the workers. Do you think courts are tech savvy enough to be always able to detect this kind of discrimination, or we'll have a big problem in the in the skills that the judge can put forward when they have to deal with this kind of cases? Alessio, you want to start?
Yeah, sure. Well, I mean, I think the main difference is the fact that, in location or geographically tethered platforms, the workers are all located in one specific place. So like, although the company may be a multinational, the platform might be operating from Silicon Valley or from, a main venture capital center across Europe or the Far East. Workers will be placed in a specific workplace. Whilst with cloud work, what we see is really a planetary labor market. Mark Graham, who's the director of FWO, has spoken a lot about this planetary labor market. And so, of course, this engenders different types of inequality on a global scale, because crowd workers are generally located in the global south. The vast majority of cloud workers are located in the global south. This is not necessarily the case with location-based platforms. Of course, you would have an internal kind of like inequality. As I mentioned in the presentation, a lot of these workers are migrants or from ethnic background, or from kind of more marginalized minority. But of course, this changes the overall dynamic. And another aspect is that cloud workers are much more invisible. They're invisible to the law, they're invisible to regulations, but they're also invisible to each other. Uber drivers, delivery riders, or more generally food delivery and ride-hailing sectors workers have online groups. They can meet in real life. For cloud workers, this is much more difficult. So even in terms of re-embedding these workers into networks of solidarity, to nexus of resistance, or into some form of pressure or accountability to platforms, this is much more difficult. And in relation to this, of course, platform workers in the UK will probably, apart from meeting each other, they're probably going to speak English at least. Platform workers in Latin America, they might all speak Spanish, while cloud workers working for Amazon Mechanical Turk might be located in very different geographical locations, different time zones, different cultures, different languages. So their ability to coordinate any form of collective actions and to counterbalance the power of platforms is much, much more difficult.
Thank you, Alessio. Uma, before we go to Elena for the concluding question, you want to say something on this?
Yeah, thanks a lot. I really enjoyed all the presentations. This is much more a reaction to what Alessio was saying about the location-based platforms. I think we somehow tend to concentrate ourselves on taxi and delivery, which have been much more discussed, talked about, largely because of the court cases that have come in. And we tend to think that, yes, there is a lot of interaction that is there among workers, but I think there are a number of location-based platforms, such as domestic workers or care workers or other home-based workers that you see, who are, again, like the crowd workers, quite dispersed, actually. And it's very difficult to coordinate and have any sort of an action. And I always have a fear that having this concentration that we have on our work on taxi and delivery, we also miss the larger, a part of the penetrations that platforms are having and having an impact on the workers. I think I'd like you to keep that in mind. Thank you.
Thank you, Uma. And luckily we will have Natalie tomorrow that will speak about domestic work and care work in the gig economy. Elena, please.
Yes, thank you for your question. Maybe I sounded more tranchant than I wanted when I say that the judge didn't understand the functioning of algorithm. They did understand that she actually was a sole judge. She understood very well that the algorithm was treating differently workers on the basis of many factors, among which one was especially relevant, in particular the rate the rate of the cancellations of the pre-book work slot booked by the workers themselves. And the judge observed that if I decide to cancel a slot that I previously booked in order to perform a certain task, certain working activities, I might decide to do that either because I want to create an organizational problem for my employer, meaning I'm taking a collective action together with other workers, therefore I'm exercising a right there. Either I could be forced to do so because I'm sick, because I have to take care of someone who needs me, maybe my children, maybe someone who needs my support, and so forth and so on. And the judge underlined that the algorithm does not distinguish whether I cancel my pre-booked activity for a legitimate reasons, taking care of a child, undertaking a collective action organized together with other workers, or whether I just cancel my previously booked activity for no reasons at all, or just because I decide to do so, because I want to take my afternoon free instead. This was the factor that pushes the judges in affirming that not distinguishing, treating the same way all these situations ended up indirectly discriminating those workers who were exercising their rights. Therefore, the judge actually understood that this was a factor used by the algorithm. It did not really went into the details of the weight of such factors together with others. For example, the relevance of such factors over the time, whether it was actually true that they were counted for a certain amount of time and no longer than that. So it didn't really go into the details, but it was well aware of the discriminatory, in this case, indirectly discriminatory effects of the algorithms. And of course, it's difficult to say if in general judges are well equipped to understand the functioning and the potential discriminatory effects of algorithms. I guess, I don't want to simplify too much, but I guess that this part of the law that stresses the relevance of the effects rather than the causes is kind of helpful here, because if we need to go through the whole process implemented through an algorithm, probably we will need, I don't know, an engineering degree every time, which is not the easiest way to go. I don't know if I answer your question.
Thank you. Yes, perfectly. Okay, so we are now closing this first session. We have a break now of almost half an hour, and we see each other at 4 in Brussels, and I guess other times around the world. See you in half an hour. Thanks a lot for the presentations and the questions and the debate. It was a very good first session, and see you very soon.